Hey, everybody. Always eyes watching you and the voice enveloping you, asleep or awake, indoors or out of doors, in the bath or in the bed, no escape. Nothing was your own except the few cubic centimeters in your skull. That's pretty deep, isn't it? So why am I quoting from classic literature? And kudos to all of you that know that that is from George Orwell's 1984. Well, there's two reasons I'm quoting from classic literature. One is because my guest today, Allyson Terpsma, who you all know, at least those of you that follow this podcast, went to a hoity-toity Ivy League school. And two, because Allyson called me and said, hey, we need to do a shanty on surveillance. So I immediately thought of Big Brother. So Allyson, why do we need to do a shanty? Why do these good people who are watching us need to know about employee surveillance?
Well, Zoe, thanks for having me. Of course, employee surveillance has been on our radar as employment attorneys for a long time. But recently, a colleague of ours directed me to a podcast on the topic. It was produced by the New York Times. They have a podcast called The Daily. And that podcast described several recent developments in employee monitoring and surveillance. But it didn't really address the full range of relevant legal considerations. So I thought it'd be a good shanty topic so your listeners could hear about what's going on in the world of employee surveillance, but also be attuned to some of the legal concerns that could arise when they're monitoring their employees.
See what I mean about hoity-toity? The New York Times podcast, of course. So what are some of these recent developments?
All right. Well, as you know, monitoring software programs have been around for the last decade or so. They started more so in call centers and warehouses, but the industry really exploded during the pandemic. During that time, all sorts of employers perceived what they saw as an urgent need to monitor employees who were suddenly all working from home. And now many employees continue to want to work from home. And so employers feel really justified in undertaking more extreme levels of surveillance in order to keep tabs on their remote workers.
Okay, so what kind of software programs are we talking about?
Well, there's a real range out there. So on the perhaps least intrusive end, some programs just run in the background and keep track of how employees spend their days, whether they're composing emails in Outlook, researching online, running analyses in Microsoft Excel, creating other types of work product, et cetera. With those types of programs, there's a lot of information, too much to sort of keep track of on an ongoing basis. So an employer may just spot check it from time to time or dig in if they have any concerns, performance concerns about a particular employee. Others may track the amount of idle time throughout the day and then aggregate it and send it in a report to the employer. Other programs will take snapshots at some random point of time within some sort of temporal interval to confirm whether the employee was working based on whether their face is in front of the monitor when they take the snapshot or whether the keyboard is active. And as an entertaining side note, I also learned that some enterprising employees have already figured out ways to try to cheat these programs.
Oh, really? How do you cheat the program?
Well, apparently there's a device out there called a mouse jiggler. And when you attach a mouse jiggler to your keyboard, it actually creates the appearance of computer activity, even if you yourself are away from your computer. So there's already things out there that employees are using to mess with Big Brother, so to speak.
Yeah, of course there are. All right, so what about the law? What are the relevant legal issues to consider here?
Sure. So the obvious issue that comes to mind first is privacy. Now, typically, courts have weighed an employer's legitimate business interest in monitoring their employees against employees' reasonable expectation of privacy. So we've always recommended telling employees in their employee handbook and having them acknowledge that they understand they'll be monitored when using their employer's technology. So really, they don't have an argument that they had any reasonable expectation of privacy. But even that protection only goes so far for employers. For example, even if your employees specifically acknowledge and agree to in-home monitoring with occasional webcam shots or microphone recordings while they're working on their company laptop remotely, family members in the background did not agree or acknowledge to that. So there's still some potential privacy concerns on that front. Similarly, if you are able to see through your monitoring software that your employee is using their personal email account, that acknowledgement does not give you the right to read their personal communications. Doing so would violate laws like the Stored Communications Act. So you still need to be wary of not taking that intrusion too far.
So I slid off camera because the guy next door is cutting his lawn. This is the joy of working in your backyard. Anything else we need to worry about legally? Any other considerations?
Well, another major issue is the potential for wage hour violations. In fact, the very first example that the podcast from the New York Times discussed was a woman who took a remote job managing a software company's finances. She was paid on an hourly basis, and the monitoring system that her employer used was one of those programs that took a snapshot at some random time within every 10-minute increment of her workday. But rather than simply use that program to monitor her productivity and performance, the employer was actually not paying her for any 10-minute increment when the snapshot suggested that she was not active on her computer at that time.
That's obviously a problem.
Sure is. So, of course, she may have been working away from her computer at that moment that the snapshot was taken. For all we know, she was taking a work call at that time and simultaneously stretching her legs. Perhaps she had printed some long report and was reading it away from her computer. We just don't know. But even if she wasn't working at that particular moment when the snapshot was taken, she may have been working the other 9 minutes of that 10-minute interval. And under the Federal Fair Labor Standards Act, all hourly non-exempt employees have to be paid for all hours that they're working. Relatedly, penalizing employees for not being at their computer at every check-in snapshot could be problematic if it has the impact of limiting restroom use. So OSHA, the Occupational Safety and Health Administration, requires employers to allow workers to leave their work locations to use a restroom when needed and avoid imposing unreasonable restrictions on restroom use. And typically bathroom breaks are short enough that they have to be paid under the FLSA. So that could be an issue as well.
All right. So lesson number one is don't cut people's pay based on any of this fancy technology. So if we can't cut people's pay based on any of this fancy technology, what can we do? What good is it?
Well, we can certainly use it as a performance management tool rather than a time tracking tool. We can use it to monitor productivity, and perhaps that could impact the employee's performance review or future bonuses or raises, or maybe it would even lead to discipline or termination if it was problematic enough. It's also useful to protect against a whole host of other concerns like data theft, confidentiality breaches, cyberbullying, harassment, things of that nature.
Okay. Any final tips on the appropriate use of this stuff?
Well, as we've discussed, you want to be sure you're disclosing the monitoring that you're doing to your employees to avoid any privacy concerns. You can use it to monitor performance, but not to track time for payment purposes. And I would encourage employers to think about the true definition of productivity and performance for each position that you're monitoring. For most jobs, the amount of time at a computer or the number of keystrokes won't provide a complete picture of productivity. It doesn't mean you can't use it effectively as one input, but you should think about how you want to use that input. Is it going to be on a regular, ongoing basis, or only as a second step, perhaps when performance concerns arise? Or maybe you want to use it to incentivize high performers rather than discipline or even weed out low performance. When making these decisions, just keep in mind how it's likely to impact morale and worker retention. Be transparent, be consistent, and then you can use the monitoring program really effectively in certain situations.
Anything else?
That's all I've got for you today. I think that's
not
enough.
Okay.
Yeah.
Well, thank you very much. I appreciate you coming on. A lot to think about, whether or not you want to use this technology. I'm just going to put one editorial comment in here. You guys are all having trouble finding employees to come work for you anyway. So before you start putting this stuff in place, think about how you're going to use it and whether or not it becomes a burden or a hindrance to getting people rather than a tool for productivity. So have a good, solid plan for if and when you're going to use this stuff. And remember, Big Brother is watching you. See you next time.
Bye, everyone.